Welcome to another episode of Taxplaining. Ashley and I are thrilled to have Jonathan Wilson join us again for the latest in the ongoing legal battle over the Corporate Transparency Act. Before I pass the mic, I highly encourage listeners to find the previous Taxplaining episode located on YouTube, featuring Jonathan here to more fully grasp how we arrived where we are today. But now let's catch up with Jonathan and discover why January 10th is the next crucial date in this saga.
Absolutely. So to bring everyone up to speed, we have the federal district court on December 3 that issues an injunction that halts the Corporate Transparency Act nationwide. Then the government appeals to the Fifth Circuit Court of Appeals. December 23, the Fifth Circuit stays the injunction. December 26, the Fifth Circuit reverses itself. So the injunction is now back in effect. And then on New Year's Eve, the government petitions the United States Supreme Court to stay the preliminary injunction that's down at the district court, pending the outcome of all the appeals in the Fifth Circuit. In response, Justice Alito in early January says that he'll accept a brief from the plaintiffs below by this Friday, January the 10th. So we're all waiting now for the plaintiffs to file their reply brief, January 10th. In the past, the Supreme Court has generally turned on these state petitions fairly quickly, meaning in a matter of 2, 3, 4 days. So it's fairly likely that by the middle of January, we will have some kind of a ruling from the Supreme Court.
What a flurry of changes right at the end of the year. And I think that on New Year's Eve, that was filed even late in the day, right? So it was like BOI ping pong.
I don't know that I've ever seen anything like this over a period of really less than 30 days to go from injunction, stay of the injunction, reversal of the stay, petition for a new stay at the Supreme Court. I can't think of a time that that's happened before.
I know it's speculative, but what do you, if you had to guess, what do you think we're going to see happen on the 10th?
Sure. So the government's petition, which is about 150 pages long, makes three basic arguments. First, they have to say that they're likely to prevail on the merits. That's getting at the constitutionality of the CTA itself. I think it's unlikely that the Supreme Court will act on that argument because they haven't had any appellate courts weigh in yet on the constitutionality of the CTA itself. We've only had a few district court rulings, and generally speaking, the Supreme Court is not going to get ahead of itself. It's not going to give everybody the answer before the circuit courts have the chance to weigh in. The issue where there is possibility for some action is on the stay itself. And that is this, down at the trial court, the plaintiffs, which were 4 different businesses, they petitioned for an injunction that would prevent the government from enforcing the CTA against them, 4 individual businesses. What the district court did was say, okay, we're going to enjoin the government from enforcing the law against you, and we're also going to enjoin the government from enforcing the law against anywhere else, anywhere. That's what they called a universal injunction. And there is some suggestion that the Supreme Court is now hostile to universal injunctions. As I've written about in a couple of my articles, there was a case called Labrador versus Poe in April of 2024 that was sort of the inverse of this. The plaintiffs there had sued the state of Idaho, claiming that a new Idaho law was unconstitutional. A federal district court had enjoined the state of Idaho from enforcing that law against these plaintiffs and also against anyone, anywhere. It was a universal injunction. The Ninth Circuit Court of Appeals upheld the district court on motion to stay to the Supreme Court. The Supreme Court modified the injunction so that it only applied to the individual plaintiffs below and not to everyone everywhere. In a concurring opinion, Justice Gorsuch, joined by Alito and Thomas, in essence said that there should never be a universal injunction, that courts should only be deciding cases and controversies to the parties that are before the court. And when a district court steps out and issues a universal injunction, it is in essence legislating to non-parties who are not before the court. They also, in the concurring opinion, Justice Gorsuch also outlined a number of very practical reasons why universal injunctions are a bad idea. In essence, they allow a single federal judge to put the brakes on a law for everybody everywhere. That in turn induces the government to have to fight all of those injunctions and then appeal them on an interlocutory basis all the way to the Supreme Court. In essence, having the availability of a universal injunction only ensures that there will be more universal injunction. So at least those 3 of the 9 justices are on record saying that they are hostile to universal injunctions. And so this will be an interesting test case for that particular way of thinking.
Yeah, absolutely. However they rule in this case on that particular issue is going to have wide-reaching ramifications, and I think this argument that it's overbroad when the way that they've applied it to essentially everyone, including those not before the court, I think is a really important issue.
There's an interesting piece of legal political jujitsu going on here. Some of the hostility to the CTA has come from the business community, which perceives itself as being aligned with the Republican Party. And we know that in Congress, a number of Republicans have criticized the CTA and have criticized the way that FinCEN has implemented the CTA. So you might think of this as being injunction is the Republican side, stay the injunction is the Democratic side. But if you were giving advice to the incoming administration, a new Republican administration, the advice you would give would be don't make the injunction be your friend, because universal injunctions are how the opponents of the new administration are going to try to tie it up in knots in the courts. If you were on the side of the new administration, you would want to eliminate the universal injunction and therefore stay the injunction in this case, arguing that there should never be one, because that's going to make it easier for the new administration to take the initiative and enforce federal law, and sometimes in opposition to states and municipalities, because there won't be a federal judge who could issue a universal injunction that would affect all plaintiffs everywhere.
Interesting.
That is very interesting.
Let's say there is no CTA in the future. Some states have enacted CTA-like statutes. Really, in some cases, I think mirror images of the CTA. uh, those are not affected. However, this plays out. Isn't that correct, Jonathan? Like those,
Absolutely.
yeah, they're still in play. And so, if you have clients right now and they think, okay, the CTA is about to be quashed, we're free of obligation. Some of them need a heads up still about the state versions. And then pretending the CTA is obliterated, but the state ones are in play. Where do you think that leaves us in our fight for transparency and stopping the use of illicit funding, the whole protective point of the CTA? How effective are those state statutes? What does that look like?
Sure. Well, that's a great question, because if you're giving advice to the new administration, I think the advice should be don't kill off the CTA. Instead, fix it, make it better. If the CTA were to go away tomorrow, let's say Congress repeals it, as you say, there's still going to be state level CTAs in several different states, and they are not going to solve the underlying problem, which is a lack of corporate transparency that leads to money laundering. As viewers know, the United States was criticized by the FATF for failing to have transparency at the corporate ownership level that led the United States, in the words of some, to be the money laundering capital of the world. Well, that problem springs right back into place if we don't implement the CTA. My advice for the new administration would be to fix it by regulation. That's something that a new Treasury Secretary and a new Director of FinCEN could do without having to have an act of Congress. They could eliminate the requirement, for example, of uploading driver's licenses, which is a big pain in the neck. They could clarify the definition of beneficial owner and the definition of substantial control to provide a more concise and bright line test that is easier for business owners to administer without getting the advice from a lawyer. And they could even, because the statute doesn't require the 30-day amendment rule, by regulation, a new director of FinCEN could eliminate or revise the 30-day amendment rule, perhaps require a quarterly update from reporting companies. It would be much easier to track and administer than the current 30-day amendment rule. So those three regulatory changes are entirely within the discretion of the new administration. No act of Congress required. You do that and you still satisfy the requirements of the FATF and keep us off of the naughty list from the money laundering point of view. And you have something that is much less burdensome for small business to actually comply with.
With all of this happening at the end of the year, I know it's a busy time for practitioners in general. You know, if you're in a professional services industry, you're catering to business clients. they're trying to do all kinds of things at the end of the year. And sometimes it's just a rush for everyone. And so for those out there who may be like me and didn't have time to dig into all of this from a procedural standpoint as it was unfolding, can you give our listeners an idea of what we can expect depending on how the Supreme Court rules from a procedural standpoint? What happens next? Where does the case go from there?
Absolutely. So where we sit today is that the preliminary injunction remains in effect, which means that the CTA is effectively not in force. Nobody has to file today. If the injunction were to be modified so that it only applies to the named plaintiffs below, at that point, the CTA and its regulations would spring back into effect. The last time that happened, in between December 23 and December 26, FinCEN said that January 1 deadline you've been tracking, we're going to push it out to January the 13th. So if we got that kind of action in mid-January, I would expect to see a roughly 2-week extension. And unfortunately, that means that millions of businesses are going to have to immediately leap into action and get their reports filed. The ones that were due January 1 will now be due on some new deadline. Those reporting companies that are located in the state of Florida previously had until July 1 to file theirs. They had a big extension as a result of the hurricanes in the fall. Presumably that July 1 deadline would then spring into place for them. So that's what the timing looks like if we get some kind of modification to stay.
Okay.
Yeah. Jonathan, is there anything you think we should cover still?
Well, I think we probably should come back after the Supreme Court does whatever it does, just to see what that is going to be. It's interesting because in that Poe case that I mentioned back in April, it was sort of the liberal wing of the court arguing in favor of the universal injunction. If that liberal wing now wants to uphold the Corporate Transparency Act, perhaps they're all going to switch sides. So it'll really be interesting to see how the court deals with this petition for stay.
Follow up.
Yeah.
Obviously, we would love to have you again, Jonathan, with the latest. And actually, Jonathan, I do encourage listeners to follow Jonathan. He's obviously the expert on this subject. Yeah, whatever I know about it, I pretty much get from following Jonathan regularly. So, Jonathan, if you want to plug yourself or FinCEN Report, tell the audience about that.
Folks who want to catch up with me, I'm the CEO and co-founder of FinCENReport.com, FINCENReport.com. You can always drop me a line there at info@FinCENReport.com. And you can find me on LinkedIn through FinCEN Report and through my name, Jonathan B. Wilson. Following me on LinkedIn is an easy way to keep track of what I'm writing about.
Thanks again, Jonathan.
Thank you.
Thank you both. Mary and
All
Ashley,
right.
thank you.
Signing off.